Okay. Okay, so thanks everyone for joining us. I'm here with Lauren today to talk about minimizing the risk of food labeling litigation. Lauren has been with us before doing other webinars, so we just saw that, like, we did another webinar with her since the first one was great. I hope that everyone that is here today is in our Slack community. I'll drop the link here in the chat. It's a place just where you can ask any questions that you have. Lauren's there too, and a lot of people just answer your questions, sharing amazing information that you need to grow your CPG company. So yeah, without further ado, Lauren, I'll let you introduce yourself and you can start sharing your screen. Oh, just sorry, one quick thing. We have a feature here called Q&A. So if you have any questions, drop on the Q&A so it's easier for us to, just follow all the questions we have so it don't get lost on the chat. Okay, Lauren, goes to you.
All right. So can you see that?
Yeah.
Okay, great. So hi. I'm Lauren Handel, and I have a small law firm called Handel Food Law. I'm based in New Jersey, but it's a virtual practice. I have clients all over the country and in other countries as well. And all of my clients are food businesses. That's why it's food law. A lot of what I do is advise people on the labeling and advertising of their products. So today's topic is minimizing litigation risks of food labeling. Also applies to advertising. And just have to give the general disclaimer that this isn't to be construed as legal advice, and consult with a lawyer to get advice specific to your needs. So let's just start with some background. I'm going to be focused mostly on labeling, but I just want you to be aware of the kinds of content that potentially could get you in trouble, both from a litigation standpoint, but also from a regulatory standpoint. So obviously labels, but also other kinds of marketing materials like your sell sheets, your website, advertising, which could be both traditional advertising or social media, things that you say, signage, things at trade shows. Really all kinds of marketing materials are both subject to regulation and potentially could get you in some kind of litigation trouble. So also some background. Who regulates the labeling and advertising of food products, food and beverage products? So in general, the Food and Drug Administration, FDA, has authority for all food generally, but primary jurisdiction for certain kinds of products, so specifically for meat, poultry, catfish, egg products that are outside of the shell. The labeling of those are regulated by the U.S. Department of Agriculture. USDA also has responsibility for the organic food labeling regulations and the bioengineered food disclosure. So that's GMO labeling, which is fairly new labeling law. With respect to advertising, the Federal Trade Commission has federal jurisdiction over all kinds of advertising and also consumer protection. States also have jurisdiction over labels and advertising. With respect to labeling, states can impose additional requirements. So state law in our system, our constitutional federalist system, state law can't conflict with federal law, but states can have extra labeling requirements. So California's Prop 65 is a really good example of that, where state law requires labeling beyond what is required in federal law. And states also have their own consumer protection laws, which is where a lot of the litigation comes in. I've included litigation plaintiffs and their lawyers in this slide, which you might think of as kind of strange since this is about regulation, but you can think of litigation as basically a form of regulation. Litigation is very much filling in gaps in regulation and in regulatory enforcement, where honestly the regulators don't have the bandwidth and haven't made it a priority to aggressively enforce the labeling laws that do exist. And that's left room for class action plaintiffs' lawyers to step in and bring lawsuits to challenge the labeling of food and beverage products. Lawsuits also can be brought on behalf of advocacy groups, such as nonprofit public interest groups, and also by competitors against each other. An important thing to understand about the oversight of labels from a regulatory standpoint is FDA works differently than USDA in this regard. So FDA does not review your labels, does not pre-approve any claims for conventional foods and beverages or even for dietary supplements. It's basically you have to ensure compliance yourself, put a product out in the market, and if FDA becomes aware of a violation, it might take enforcement action against it. In contrast to that, USDA, if a label makes what are called special statements or claims, anything, claims such as humanely raised, natural, free, claims about the absence of antibiotics, and there's a variety of issues that can trigger what's called sketch approval, meaning that you have to actually submit a draft of the label to USDA's Food Safety Inspection Service to be reviewed, along with substantiating documentation, and get their approval before you can use the label in the marketplace. So misbranding is a concept in food law. It's one of the big prohibitions that you shall not misbrand food. And there can be a variety of understandings of what is misbranding. It's illegal to sell a food product that is misbranded, to cause it to be misbranded, even just to hold a product that is misbranded for distribution in the United States. So misbranding can be labeling that's false or misleading. That can be because it makes statements of fact that are inaccurate or that are deceptive. But it can also be what's not said. It can also be the failure to disclose material facts and things that the consumer would need to know about the product that you don't mention. Misbranding also can be packaging that's misleading as to the fill of the container, so as to the quantity of the product that's inside. If consumers see a really big package, but there's not, it's only a quarter of the way full, that could be a form of misbranding. And then there's also what's kind of technical misbranding. So even if consumers aren't deceived, if you fail to follow the many rules that exist about food labeling, that's also misbranding and makes the product illegal. So that can be failing to include some piece of mandatory information. It can be not complying with the regulations around different kinds of claims. So certain kinds of claims have very specific rules, for example, claims about nutrient content. It can be not having the correct statement of identity, or having a product that uses the name of a product for which there is a food standard or a standard of identity without actually meeting the requirements for that food. Characterizing flavor labeling is also, there's a very technical, really difficult to understand regulation about how you describe characterizing flavors. So, those are some examples of the different types of labeling rules that exist, and the violation of which constitutes misbranding. So turning to litigation. Consumer class action litigation. So most of the litigation that exists around food labeling is consumer class actions. They're brought under state law, not federal law. And the basic things that the plaintiff needs to show in this kind of case is that something about the label is likely to deceive reasonable consumers. So it can't be just some crazy interpretation of a representation on a label, but rather that reasonable consumers seeing this label are likely to be deceived. That has to be a misrepresentation that actually matters to consumers, that's material to their purchasing decisions. And then also that the consumers have been harmed in some way by this. And so there's basically two forms of that. One can be that the consumers paid more for the product than it was actually worth. So had it been labeled correctly, it would have commanded a lower price. Or they were tricked into buying a product that they otherwise would not have purchased at all. So in that case, their damage is the full amount that they paid for the product. And also these are class actions. So for those of you who might not be familiar with civil procedure, a class action is a tool where a named plaintiff, one or more people who serve as the named plaintiffs in the case, represent a whole class of people. So in these cases, it's generally all consumers of the product in one or more states over a period of time, whatever the statute of limitations period is. So 4 or 5 years, something like that. Or it can be all consumers nationwide of the product. And so you can see that the potential damages. So if the plaintiffs were to succeed and prove a case, even though maybe per consumer, the amount of harm that anyone could have suffered is very small, cents or dollars, over the entire class, if a product has any significant distribution over several years, you can see how the damages could add up. So some things to understand, again, for people who might not be really familiar with how litigation works and sort of what this is all about. In our system in the United States, it is pretty easy to initiate a lawsuit. You have to have a plaintiff, you have to have a theory of a case and write a complaint that satisfies some certain bare minimum requirements to put the defendant on notice of what the claim is about. But it doesn't cost very much to initiate a lawsuit, and it's not very difficult to draft a complaint that is strong enough to at least get through the early knockout motion to dismiss, right? So as a defendant, if you're facing a case like this, you can try to get it dismissed outright. And as a defendant, that's very difficult to do because there's just not a very high bar for plaintiffs to meet to have a case that can survive at least past that initial stage and then get into discovery and all the other things that happen, motion practice that happens, and the depositions and document exchange and everything that leads up to a trial. In our system, usually each party pays its own lawyers and its own costs of litigation. There can be some exceptions to that, but if you're the defendant thinking that you're going to get your legal fees back from a plaintiff if you win, that is not how it works in this country, except in really unusual circumstances where there were sanctions, where the conduct of the plaintiffs was so egregious in bringing this case where possibly you could get sanctions against them, but that's really rare. So usually you're going to pay your own cost of defense. It's expensive, right? Especially if you don't win on that early motion to dismiss, it's expensive, it's time consuming. It eats up a lot of resources to be involved in litigation. And so it should not be surprising that the vast majority of cases will settle. It's also, unpredictable what the outcome will be of any case. But given the cost and the effort involved, there's a lot of incentives to try to settle lawsuits quickly. And that's really what goes on in a lot of these cases is the plaintiff's lawyers know that it's really unlikely that they could win. They have enough of a case that they can, in good faith, without violating attorney ethics rules, file a complaint. And the incentives, usually, especially for smaller defendants, will be to try to get rid of the case as quickly as possible because it's expensive to defend, even if you could win as a defendant. Now that's different. The incentives can be different when you're bigger. If you're a bigger company where you're a likely target for copycat litigation or to just get hit with litigation all the time and you have the resources to defend, then you have to defend. So big food companies have to fight back and they can't send the message out to the plaintiff's bar that they're an easy target. If you sue us, we'll just pay you off. So some more on kind of the realities of all of this. These days, there is a greater risk. Your food labeling presents a greater risk that you will get sued or threatened with a lawsuit than that you will face any sort of regulatory enforcement action. And that's, like I said, especially for FDA regulated products, it's just not a priority of the agency, and they can't go after everybody for their labeling violations. That said, a priority of FDA is to go after people who make what are called drug claims or disease claims. So if you are putting out in your advertising or your labeling that your product is useful to cure or treat or mitigate disease, well, FDA, expect to hear from FDA about that eventually. That is a priority of FDA. But also when FDA takes action, usually it's a warning letter. They don't sue you, except in really extreme circumstances. You get a warning letter, you get a chance to correct your labeling. You usually don't have to pull product off the market to do that. It can be with your next print of labels, usually. So the risk of regulatory enforcement usually isn't that big. I will say that for particular kinds of issues in some states, it can be a little bit more severe, where states might take more action to actually embargo your products to require you to pull them off the market. But usually the regulatory threat is not as great as the risk these days of at least getting threatened with a lawsuit. When I say that, what I mean by the threat is a demand letter. So often, especially for cases that are going to be brought in California or brought under California law, under the law, the plaintiffs have to give notice of their intent to bring the lawsuit before they file. And so you'll get a letter saying basically everything that would be in the complaint, sometimes attaching a draft of the complaint and demanding that you take some action or you will be sued. And those are, designed to give the parties a chance to make corrections and to try to settle the matter before it ends up in litigation. Something else that's important to understand is that complying with the rules is important. It's also not enough. So the fact that your label technically complied with FDA regulations is not necessarily a good enough defense, because there's still the possibility that under state consumer protection law, the representations you're making are deceiving consumers, even if they comply with FDA rules. This is a big one that I get all the time from my clients, who I point out various things about their label and they tell me X, Y, and Z competitor is doing the same thing. That's never going to matter to a plaintiff's lawyer. It is not a defense if it actually is false or misleading to consumers, or if it is an FDA labeling violation. It doesn't matter what competitors are doing. It's what I tell people all the time. You can't tell what the speed limit is by looking at what speed other drivers are driving. Don't look to other people for evidence of what you're required to do. And finally, no brand is too small to get sued. So you would think that plaintiffs' lawyers, especially class action plaintiffs' lawyers, are targeting the deep pockets, and they do, for sure they do. But there is a segment of the plaintiffs' bar that is deliberately targeting very small brands. I've had clients that just launched, clients that have really low levels of sales who get demand letters and threatened with lawsuits. And this is an intentional thing. Like I said, it's easy to do this. These complaints usually are cut and paste, just the plaintiffs' lawyers can regurgitate the same complaint over and over and just change the name of the product. They hit on a particular theory of what's deceptive, and I'm going to go through examples of these, and then can go around, often find these products either on store shelves or online, and just send out dozens and dozens of these demand letters. And they know that small brands can't afford to defend, so they have high incentives to try to settle quickly, to try to settle before the case ends up in court and becomes public. And if they can make a few, even $20,000, $30,000 a pop, and do this a bunch of times, they can do pretty well and fund themselves while they're engaged in the longer term litigation against the bigger companies that are fighting back. So I'm going to go through examples of these are the targets that have been popular for class action plaintiffs in the last really 10 years, but especially within the last few years. of the kinds of labeling issues that are most targeted in these cases. Natural and different versions of natural, no artificial flavors or preservatives types claims, what I call health washing, or representing that a product might be better for you than it actually is. Really technical violations around nutrient content claim labeling, representations about characterizing flavors or key ingredients, animal welfare, greenwashing or sort of environmental benefits kinds of claims, slack fill, which I already described, and in California, Prop 65. So natural. Initially, this food labeling litigation, really about 10 years ago, is when it really started to become a popular type of class action litigation. And many of those cases were focused on products that were labeled as all natural. And this is an area, as I mentioned, there are gaps in the regulations that exist that leave room for plaintiffs' lawyers to step in. And here, there's no regulation that defines the term natural with respect to food or beverages. FDA has an informal definition. It has issued guidance saying that it won't object if someone labels a food as natural, as long as it contains nothing artificial or synthetic and no coloring. So that means even coloring from natural sources that consumers would not normally expect. Your guess is as good as anyone else's as to what consumers would normally expect. It's a fuzzy standard, but again, it's not law. It doesn't have the force of law. And it's also not intended to address production methods or the processing. So from FDA's standpoint, its definition is really meant to consider only the finished product and not how it's made. So for example, not the fact that GMOs were used to grow the crops that were then turned into ingredients that are in the product. USDA also doesn't have a regulation that defines natural, but it has an informal definition in its policies that natural is okay as long as the product has no artificial flavors, coloring ingredients, chemical preservatives, or any other artificial or synthetic ingredient, and that the product and its ingredients are not more than minimally processed. USDA also requires that products that are labeled as natural have to have a little disclosure statement explaining what the manufacturer or the brand owner means by that. So for example, no more than minimally processed and contains no artificial ingredients. And FDA, a while back, FDA had issued a few warning letters to companies objecting to their use of natural, but it's really done nothing like that in a long time. Because of all the litigation, there had been pressure on FDA to do something about this and to actually define what is natural so that people can have some certainty about when they can use that term without getting sued. And FDA actually put out a request for public comments on this. The comment period closed in May of 2016. And it asked people to tell the agency if it's appropriate to even define the term natural, how it could define natural, and how it should determine the appropriate use of the term on food labels. And in 2018, the commissioner at the time said that FDA was actively working on the issue, but there's been radio silence since then. So no one knows if or when FDA will actually do something about this. So some examples of the kinds of products that get targeted. And a lot of this has died down. So brand owners and manufacturers were getting sued a lot for this issue. And so many just have stopped using the term natural altogether. But the kinds of cases that have been brought involve products like this. So the examples I'm going to give you are actual cases. There are citations in the slides, so you could actually find these cases if you were interested and look them up. But in this case, canola oil was labeled pure and 100% natural. And the allegation is that it's not natural because canola is made with GMOs, and that's not natural. Other products, if they have various synthetic, artificial, or even highly processed ingredients. So a lot of cases involved high fructose corn syrup, which comes from corn, a natural commodity, but is very highly processed and is therefore arguably not natural. Products that were tested by the plaintiff's lawyers and found to contain traces of herbicides or pesticide residues that were labeled as all natural, or products like dairy products that have been tested and found to contain antibiotic residues. So like I said, a lot of the industry has moved away from using the word natural and is using other things. And likewise, the plaintiff's lawyers are seizing on this alternate language and saying that this now means to consumers all natural. So here's an example: Tropicana apple juice. It's just labeled 100% juice. It contains malic acid, which is synthetic. And the allegations in this complaint are not just that it's not 100% juice because there's something beyond juice in there, but that consumers understand a representation like that to mean that the product is entirely natural. There have been other examples of this, products labeled pure or even plant-based, where the plaintiffs have alleged that consumers understand those terms to mean natural. No artificial flavors and preservatives. So here's an example: Crystal A. It says no artificial sweeteners, flavors, or preservatives. And those, so the artificial flavors is a defined term in FDA regulations. So it's a flavoring ingredient that is made from artificial sources. Preservatives, chemical preservatives, is defined in FDA regulations. And this statement may be correct in terms of the meaning of those terms under FDA regulations, but the plaintiffs in these cases argue that these ingredients, so this product, I don't remember exactly which ingredients it is, but it probably has citric acid, malic acid, maybe ascorbic acid. There's a lot of these synthetic multifunction acids, ingredients that are used as acidity regulators, but the plaintiffs argue they actually do have an effect on the taste of the product, and therefore they are flavors and they are artificial. And so the statement that there's no artificial flavors is untrue. Likewise, the acids in adjusting the pH of the product will have an effect on shelf life, and therefore they are acting as preservatives, even if that's not what they were intended to do, if that's not the reason why they were added to the product. And that leaves room for the plaintiffs to argue that there are artificial preservatives in the product. Health washing. So this is kind of a broad category. It could come in a variety of forms. This is an example. There are actually several cases involving cereal products. The basic idea being that representations are made that convey to consumers that the product is nutritious and maybe healthier than it actually is. So for the most part, these are products that have relatively high amounts of added sugar. And that's, the plaintiffs have used that to argue they're not healthy. Added sugars are dangerous. And yet these products are being marketed as nutritious, healthy choices. So it's not necessarily that the product says healthy on it anywhere. This is an example of one that does not. Right? So the Raisin brand just has these various representations that it's made with real fruit, and it calls out omega-3s and protein content. And there were other things about the label and advertising that the plaintiffs pointed to say it's being represented as a healthy choice, but because of its sugar content, it's really not. So this is a good example of where you have to look at not just the specific language of any claim, but really the totality of the messaging that the brand owner is putting out there, and what messages are consumers likely to draw, and is that truthful? What's important to know kind of about health washing in particular, and the word healthy and variations of that term are defined by a set of criteria in FDA's nutrient content claim regulations. So if you use the term healthy or healthier or healthiest or any variation on that, the product can't have above a certain amount of total fat or saturated fat. It has to have at least 10% of the daily value of a quote unquote good nutrient, protein or fiber or vitamins or minerals. But right now, those regulations don't address anything about sugar or added sugar. And the plaintiffs' lawyers in these cases have said they're actually filling that gap. They're targeting products that aren't actually healthy, even if FDA regulations would have allowed them to be marketed with the word healthy. There are a lot of cases around, again, pretty technical nutrient content claim regulations. So especially for products that make representations about sugar, no sugar claims, 0 grams of sugar, no added sugar. So there's a specific rule about those and the conditions in which you can use those claims. And if the product doesn't qualify as low or reduced calorie, there needs to be a disclosure about that on the label. And so this is a kind of an easy gotcha where somebody just failed to comply with a technical part of the regulations, and the plaintiffs use that violation as their theory for why these labels are false or deceptive. In this case, I thought was interesting because goldfish crackers, it's not really a claim per se, but they use the facts up front labeling. So the keys, which are part of the Grocery Manufacturers Association facts up front labeling, include 0 grams sugar. And those actually are nutrient content claims under FDA's regulations. And for the most part, FDA doesn't apply its nutrient content claim rules to the facts up front labeling. But the 0 gram sugar is an example where FDA's rules still do apply. And so the disclosure, if it's not a low calorie food, still needs to be made. Protein content is another pretty technical, arcane kind of rule around how protein content gets labeled. Obviously, there's a lot of interest these days in higher protein products, and people want to be able to convey that to consumers. So there have been lawsuits challenging the front of pack protein content representations as overstating the actual usable amount of protein in the product. So a little bit of nutrition, not all protein is usable in your body or digests in your body in the same way. And there are different methods that labs can use to measure the amount of protein that's in a product. And for purposes of labeling, FDA says that you can use either what's called the nitrogen method, which is kind of just tells you the quantity of protein, or you can use what's called the digestibility corrected amino acid method, or the amino acid score of the product, which converts that quantity into the usable amount. From FDA's standpoint, either is fine. The plaintiffs were challenging products that were labeled using only the nitrogen method and saying, but this is protein from, let's say, almonds in this case, I'm not really sure with this cereal. And that isn't as usable as other forms of protein, and therefore you're deceiving consumers. That particular argument will no longer work given FDA's guidance on this issue, but the plaintiffs' lawyers are coming up with new versions of it. All of this is to say, be careful about how you label protein content. Be careful about actually getting it measured if you make any kind of claim about protein content. The nutrition facts panel has to state the percent daily value, and that part, the percent daily value, has to be determined using the digestibility corrected amino acid score. Implied low sugar kinds of claims, so products like this are labeled sort of sweet or a tad sweet, or there's other versions of that where it's not strictly a sugar content claim. It's not explicitly a claim that the product is low sugar, but where the plaintiffs have argued that is the message that consumers are taking away, and yet the product does have a significant amount of sugar. This is another example where this is labeling that would be allowed under FDA's regulations, but the plaintiffs' lawyers have been able to argue it's still deceptive to consumers. Representations about flavors and ingredients. There are many of these cases getting filed, mostly by one law firm. And even though his name is Spencer Sheehan and his firm, even though he keeps losing a lot of these, he's won enough of them that they keep getting filed. So there's a bunch of examples of them. The basic idea is, so this is Pop-Tarts. The allegation is that it's deceiving consumers to just call it frosted strawberry because it doesn't have nearly as much strawberry in it as consumers might think. So vanilla is another example where there have been a lot of lawsuits where the argument, if the representation is just says vanilla in the front of the package, in a lot of cases people will use an image of a vanilla bean or a vanilla flower. And if the product isn't exclusively getting its vanilla flavor from actual vanilla bean, that's alleged to be deceptive. Again, most of the courts facing these kinds of claims have found that this labeling is not deceptive as a matter of law and have dismissed them. It's a kind of unusual example where the defendants are winning motions to dismiss, but they keep getting filed and threatened before they end up in court. It's another example, fudge stripes. So, it says made with real Keebler fudge. In this case, the plaintiffs actually went to dictionary definitions of what is fudge and that it includes butter and sugar and milk, and none of those things were in this product, and therefore it's alleged to be deceiving consumers. Another example where veggie, the word veggie is being used for a product that is primarily made with grains and oils with little of what we would think of as actual vegetables. And that's alleged to be deceptive. And the defendants in this case are saying, we use veggie, like veggie burger, to just mean it doesn't have meat, and consumers aren't being deceived. Representations around how animals are raised and treated. So I mentioned before that USDA has to pre-approve labels. So if you were to make on a meat or poultry product a claim about animal welfare, you'd have to submit substantiation of some kind to USDA to back that up, and it would have to be approved. And in that case, you actually would have a very strong defense, because it's under a doctrine called preemption, because federal law has basically blessed your label, and therefore state law can't be used to attack it. But for other kinds of products like eggs and fish that are not within USDA jurisdiction, also pet food, those are fair game for attacking these kinds of representations, again, because FDA is not pre-reviewing or approving the labels. So there's no law that defines any kind of animal raising claim, other than there are some animal welfare standards in the organic standards. But terms like humane or pasture raised, antibiotic free, USDA has guidance on certain claims that it's informal. And again, it relates really only strictly to meat and poultry products that can give you some idea of what would be fair for making those sort of representations. But basically, they're fuzzy subjective terms where consumers might have a very different idea than the marketers, and therefore there is room for people to be confused or deceived. So in this case, Happy Egg Company, the label, it's a little fuzzy. It says pasture raised on over 8 acres. And the allegation is we have no idea how many chickens were being raised on 8 acres, and that actually these were pretty crowded conditions. It sounds good. They're free range, they're pasture raised. Sounds good, but in reality, maybe these are actually not the greatest conditions and don't meet industry standards for pasture raised eggs. This is an interesting example. So I just told you that USDA blesses labels, and therefore that's a good defense, but this is a case that is actually challenging the labeling of poultry and also their advertising. So USDA does not pre-approve advertising as opposed to labels, and therefore usually the plaintiffs can move forward with cases involving the advertising of meat or poultry products. But this is interesting because the challenge representation is is the certification mark, is this American Humane certified label, which means that a third-party organization has certified that the product meet its standards. And the plaintiffs have argued, but those standards aren't actually humane and consumers are deceived. Here's an example of pet food where products were labeled with this free-run poultry, and there's an example of imagery as being a claim. So there were the words free-run on the packaging, but also this picture of this really beautifully manicured green lawn with chickens running around, when in reality, the chickens never leave a building. They're always indoors. So they're free run because they're not in a cage, but they're not actually out on grass. Fish, another example, this is about sustainability. And so it's important to know that any sort of broad environmental benefit claim is going to be very difficult to substantiate. There's a lot of different possible interpretations of a term like sustainable, and it would be almost impossible for a manufacturer or brand owner to be able to back up every reasonable interpretation that a consumer could have of that term. And in this case, the salmon is labeled simple, sustainable seafood. Sustainable is not defined. This product is certified as meeting a best aquaculture practices standard, but consumers could have a much broader understanding, and the allegation is that it's not actually sustainably raised salmon, it's farm raised, and it's damaging to the environment and to the animals. Another example of a word like sustainable meaning different things to different people. This is a lawsuit against Nestle, which has labeled its chocolate as sustainably sourced. So it has its own standards and certification of sustainability, but the allegation here is that it's not sustainable because cocoa is produced using slave labor, and so it's not fair trade. It's not sustainable in its human impact without regard to any environmental considerations. Slack fill. This is an example of actual slack fill case. So if consumers will be deceived by looking at the outside of the container and think that there's more of a product in it than there actually is, that can be a basis for consumer deception, even if the product is truthfully and accurately labeled with its net weight. But some defenses can be if the consumer can see the level of fill. For example, if there's a window in the package, more and more products are being marked on the outside with the fill level to set up a defense to this kind of case, or to try to minimize the risk of having this kind of case. If the contents will normally settle, that can be a defense. And if the empty space is functional, if you need to leave extra space to protect the product, that can be a defense. Kind of different version of the case theory that consumers are getting less than they expect to get are cases where the product, in this case coffee, makes a representation about how many servings it makes. And the plaintiffs apparently tested it. They tried to make 240 cups of coffee out of the container, and they got significantly less than that. And there's actually a bunch of lawsuits around this particular Folgers coffee labeling. I would be remiss if I didn't mention Prop 65, because for a long time now, Prop 65 has been a big area of food labeling litigation. This is different than all the other litigation I've been talking about. It is typically class action litigation, but this is brought under the particular California law, Proposition 65, which requires warnings to be given on a product if it contains chemicals or can expose consumers to chemicals that are on a list of carcinogens and reproductive hazards. And if it's there at a level that exceeds a safe harbor limit that the state has set, a warning has to be given. And the failure to give that warning is a violation for which An enforcement action can be taken by the state, but also there's what's called a bounty hunter provision in the law that incentivizes plaintiffs to bring lawsuits on their own, and for which they can recover their attorney's fees. And while there is an exemption, if you're a very small business, if you have fewer than 10 employees, you're technically exempt from Prop 65. But if you're doing business with any larger distributors or retailers in California, look at the vendor terms that you have to agree to when you sell to them, because they will almost always require that you to warrant that your product is compliant with Prop 65. So you might technically be exempt. Practically, you might be required to comply just to do business. So it kind of put this in a nutshell of how can you minimize risk. As I mentioned, compliance with the rules is important. It's extra important these days because you're more likely to face enforcement from plaintiffs' lawyers than from regulators. And they really studied the FDA regulations, and a lot of these lawsuits involve really kind of technical, nitpicky violations of FDA regulations that the agency itself probably would never take action on, but they use as the basis for alleging that consumers are deceived. Compliance is not enough. I've given you examples of cases where even if the labeling complies with the labeling regulations, there still can be enough of an argument that consumers are deceived to be able to advance a lawsuit. Literal truth is not always enough, so you can't just take a claim and or a representation about a product in isolation. Even if it's literally true, there's still the possibility that consumers can be deceived based on the overall representations that are being made in the context in which this particular statement is being made. And there may be facts that are material to consumers that are being left out that they really would need to know to not be deceived by the statement. So again, you have to consider the whole overall impression, including the imagery of a product, not just the language that's used in claims. The people who are advising you on how you should market your products and what you can put on your labels. So if you are hiring marketing people, if you have lawyers or other regulatory specialists who are reviewing your labels, to be able to adequately advise you, they really need to understand the product well, understand its sourcing, what kind of substantiation you have. And then last, I understand, and all of my clients are in the food business. Most of them are CPG companies. I know this is a highly competitive industry, and that it's difficult to succeed, and that you need to be able to differentiate your products. And so you have to balance that against the risks of litigation, and what sort of business risks are you willing to take, and is the benefit you're going to get from a particular kind of positioning or messaging really going to be worth it given the risk that you might face. And that is all I have for slides. So let me stop this and see if we have some questions.
Hey, Lauren, I can like help you with the questions. We have some very good ones on the Q&A. That was a lot of good information. Thanks for sharing that. And then I have a question that I answered there like by text, but we will provide the deck after with the recording if you guys want to go over it again. So first one, if I'm developing a body lotion product that uses organic and all natural ingredients, I can't afford the organic certification right now. Can I just put made with organic shea butter on the label to get around that?
No. So easy answer. There's a regulation about this. You can only make a made with organic ingredient, name your ingredient, or up to 3 different ingredients, type claim if the product has at least 70% organic material, and it has to be certified. Certification is going to be required for any use of the word organic other than in the ingredient list itself.
Thank you for that. I hope that answered your question. I have another one from Jude. If an agency initiates an inquiry, do they always make it public, or can it be handled behind the scenes? Perhaps it depends on the issue.
Yeah, so it depends on how it comes to light, right? So if it was in the course of an inspection, so an inspection at the manufacturing facility, FDA finds a labeling issue, and that can be an inspection findings which aren't published and which you would have a chance to correct before they would issue a warning letter. Sometimes they just go ahead and issue a warning letter, and the warning letter is always published. So there's not a great way to control that. And a lot of labeling issues, they don't give you any advance warning. If they have an issue that they've discovered, they'll just issue the warning letter. It's different for states though. States don't necessarily put out anything public.
Oh, thank you for that, Lauren. Next from Tom, what terminology can safely be used regarding sustainability claims around packaging materials? So
there's no easy answer for that. It really depends on the composition of the packaging and what you could actually substantiate. I'd encourage you to look at FTC's green guides. There are several principles in there around claims that can be made about recyclability and recyclable content. California has new law that's being implemented around recyclable claims where it'll be restricted unless practically consumers can actually recycle the material in a particular place. So regulations are being developed on that now, but there's no one safe set of terms that you could use because it really just depends on the facts.
Cool. Okay, next one. What about natural flavor? Is that accepted as all natural?
So there is a disconnect between what FDA regulations mean by the term natural flavor and what consumers might understand natural to be. So a flavoring can qualify as a natural flavor under FDA's rules and still contain things that are not natural. The flavor part of it comes from a natural source, but it might have preservatives in it that are not natural. And while you might not be required to label those preservatives in your ingredient list, they might be exempt as incidental additives, it still would be untrue to say that the product is 100% natural because it's not. So there are risks and there are these disconnects between what the regulations say and what I don't think consumers are likely to understand anything about flavor labeling, honestly. It's so confusing. It's hard for me to even understand. And I've spent a lot of time with it, but no, it is not enough. The fact that you've used all natural flavors to make your product natural. Plus, I don't know what your other ingredients are, but it's complicated.
Yeah, I feel that one. Could you share more examples or issues with products that use alternative sweeteners like stevia, monk fruit, sugar alcohols, erythritol, and what are the requirements for the NF panel on those?
So there's no requirement to label sugar alcohols in the nutrition facts panel, but you're allowed to. It's an optional thing. If it's a non-caloric sweetener, it's not going to show up in the nutrition facts panel as sugar. And you're required to label your ingredients truthfully. So use the common name of the ingredients in the ingredient list, but they don't necessarily affect the nutrition panel. I'm not aware of any cases. Well, I think there have been lawsuits around products labeled as all natural that use some really highly processed alternative sweeteners, so that even if they came from natural sources originally, because of all of the processing, I would consider it risky to call a product all natural if it used as an ingredient that's really highly processed.
Okay, Next one, can you list the amount of protein your product contains, showing the serving size below without the digestibility of the protein?
Okay, so I think I understand the question. Can you, outside the nutrition facts panel, make a claim about the amount of protein in the product based on the nitrogen level, is my understanding. So what, just the flat content without digestibility? According to FDA's guidance that it was issued earlier this year, yes, you can say 6 grams protein based on its nitrogen measure of protein. However, once you've done that, that triggers a rule in FDA's regulations that you're required to include the percent daily value of the protein in the nutrition facts panel. And that percent daily value has to be determined based on digestibility.
I hope that answered your question, Chara. If not, just do a follow-up question here, please. Okay, Carlin, we make many nutrient content claims on our products. We only do so if our analytical and destructive lab test shows it. Besides keeping the COA on hand, is there anything else we should include in our records in case if anything comes up? I hope I'm reading like the CEO symbols right. Sorry if I know, you can correct me.
I understand it, right. So basically the question is, what sort of documentation or substantiation should you have to back up your nutrient content claims? I mean, so that sounds great to me that, first of all, you have lab testing to back up your nutrient content claims. And it sounds like based not only at the time of manufacture, but later on in the product shelf life. That's great, and probably more than a lot of people are doing. Technically, it is probably, so under FDA regulations, there is a tolerance for inaccuracy in nutrition labeling, basically plus or minus 20%. And that's because food isn't always the same, and you're actually allowed to use databases to create your nutrition label, and you don't have to have the product tested. So you have that kind of wiggle room. It is an open question, and I think somewhat risky to rely on that kind of data and that sort of tolerance if you're making claims outside the nutrition label, just because there's so much litigation and because plaintiffs' lawyers go out and test products. So having that lab testing and the documentation of it is great, and probably all you need. I can't think of anything else you would need. If that shows that your claims are true, then I don't know what else you would have.
Okay, he has another question. There's another question from Carling. I have an item that is primarily a single product, but then less than 0.5% of preservatives, lime juice, and ascorbic acid. Is this no longer considered 100% food item?
So I guess it depends on, it's a difference between the regulations and the litigation risk. I'd say as far as the litigation, so I gave you the example of the 100% juice. That is, apple juice is 100% juice as far as FDA is concerned. Obviously, it's not as far as plaintiffs' lawyers are concerned. There are other examples of that. Grated Parmesan cheese, for example, there have been cases about that where it says on the label it's 100% Parmesan cheese, and yet there's some filler in there or ingredients to prevent it from caking, and that was enough for the case that case actually went very far. So as a litigation issue, I'd say don't say it's 100% something if it's actually not, if there's something else in it.
Thank you. I know we are going a little over, so if you have to drop, I will send the recording later too if you want to just follow with the questions here. But we have a few more. Lauren, how many more questions can you?
I got another 5 minutes.
Okay, so I'll just follow the order I have here. What HAS to go on the ingredient label food? What does the spice included?
So there's an exception to the requirement that you label all ingredients using their common name for flavorings and spices. And so there is a definition. I don't have it memorized, but there's a definition of what counts as spices. You can find it in the regulations and look and see, but basically if it's used as spice, you can call it spice. But if it's something that consumers would think of as food, like garlic powder, you can't call that spice.
Okay, Brian, is there a materiality, threshold with respect to artificial flavors or preservatives? Are these preservatives not considered artificial?
So I'm not sure, Brian, what you mean by materiality threshold, but yeah, there are preservatives that are not artificial, like salt, right? I mean, so, you know, vinegar, right? There are natural ways to preserve products. So yes, it's not like FDA's interpretation of colors where all colors are considered artificial. And it's just a different use of the word artificial. It's an artificial color in that the product doesn't have the color it would naturally have, not that the color comes from an artificial source, but but I don't know what you mean by materiality threshold.
Okay, Brian, if you want to just comment in the chat really quick and we can see if we can like go over that. If I use a specific salt, do you have to list it, example, Cajun salt, or can you just say salt?
Okay, so I don't know what Cajun salt is.
Me neither.
Salt is table salt. If in your ingredient list it says salt, that means sodium chloride, table salt. Beyond that, if it's potassium salt, you can call it that. You actually don't have to call it potassium chloride anymore under an FDA decision. But you're not required to say sea salt or Himalayan salt, or you can just call it salt if that's what it is.
Okay, cool. Last one. So for a gluten-free product, can you make the claim on your packaging but not pay/handle paperwork for the certification?
Right. So the certification is optional. It's not required. All the labeling certifications, they're always voluntary. They're not required, except for kosher. Kosher, usually under some state laws, if you make a representation that the product is kosher, you have to have kosher certification. And also it would be deceptive to people who follow a kosher diet to not have that certification. But otherwise, they're voluntary. Gluten-free is defined in FDA regulations. So as long as the product is made without any gluten-containing ingredients, so you're not intentionally adding anything with gluten into it, and it has less than 20 parts per million in the finished product of gluten from unintentional sources. So if there's a possible cross-contact of the ingredients in the supply chain or of, within the product as it's being made in a manufacturing facility, you have to have quality assurance procedures in place to stay below that level. And as long as you've satisfied those criteria, FDA allows a gluten-free claim to be made. The certification goes beyond that, and if it's important to the positioning of the product, the certification standards are more strict than that. So it might be important, but it's not required.
Okay, cool. Wow, I think we are like 1 minute over 12:05, but Lauren, can you drop your email here in the chat? So or your website too, and I don't know if people can contact you if they have a follow-up question, or if they want to hire you, of course they can contact you. Sure,
yes, I will. And I meant to show the slide with that, but I will put it here. And I'm also in the Slack, Startup CPG Slack, so you can find me there too. But yeah, feel free to reach out if you need help with something or just have some follow-up questions. I'll be happy to get back to you.
Thank you, Lauren. So as I said, we are going to share the recording and also the PowerPoint presentation. But if you need to out to Lauren, Slack or email, that would be great. And Lauren, I really appreciate your time. And this was so good. It was like a lot of good information here.
Thanks for having me.
Yes, of course. Well, thanks everyone for joining us, and I see you guys soon.
Okay.
Bye.
Bye-bye.